She sued her neighbor, then one text message destroyed everything. She just wanted to sleep past 6 in the morning. What she got instead was a $340,000 lawsuit and a courtroom that stopped believing her the moment a single text message hit the screen. For 11 years, the woman who lived in the pale yellow house on Meridian Drive had been a model neighbor. She kept her yard clean, she attended HOA meetings, and by every account from the people who knew her, she was reasonable. Patient, even. But patience, as the court would learn, has a complicated relationship with memory. The car dealership had been there longer than she had. It occupied a sprawling lot directly adjacent to her property on the commercial side of Meridian Drive, a boundary that had always been contested in spirit, if never formally in law. The dealership sold mid-range sedans, employed around 40 people, and opened its service bay doors at 6:45 every weekday morning. For most of the surrounding area, this was background noise. For the woman in the pale yellow house, it had become, she said, unbearable. Her complaint began formally in late March, roughly 18 months before the case went to trial. She filed a noise ordinance grievance with the city, citing the service bay's pneumatic impact tools, the PA system used to page technicians, and what she described as deliberate retaliatory horn honking that she claimed began after she first complained to dealership management. The city conducted 2 inspections. Both found the dealership operating within legal decibel limits. She was not satisfied. She hired an attorney and filed a civil suit seeking $340,000. The amount she argued represented lost property value, documented medical costs for anxiety and sleep disruption, and punitive damages for what her legal team called a targeted harassment campaign. Her case, on the surface, was sympathetic. She produced a sleep study conducted by a physician showing disrupted REM cycles. She presented a log, meticulous and handwritten, spanning 7 months. Dates, times, decibel readings taken on a consumer-grade device, descriptions of specific incidents. She wept on the stand when she described calling in sick to her job 3 times in 1 month because she was, in her words, too exhausted to function. The courtroom listened carefully. She had made herself credible. The dealership's owner, a second-generation businessman who had expanded his father's single lot into a regional operation, was equally composed at the defense table. His attorney argued that the complaints were not rooted in genuine disturbance, but in a long-running dispute over a fence line that the woman had raised years earlier and lost. They pointed to the 2 city inspections. They called a certified acoustical engineer who testified that even with all service bay doors open simultaneously, the ambient noise at the woman's bedroom window was equivalent to moderate rainfall. They presented records showing the dealership had, voluntarily and without legal obligation, installed additional sound insulation baffles along the shared boundary wall within 60 days of the first complaint. They had tried to be good neighbors. That was their argument. Then the dealership's attorney introduced Exhibit 14. It was a text message thread obtained legally through discovery between the woman and her sister. The messages began 3 weeks before the formal noise complaint was ever filed. In one exchange, the woman wrote that she had found a real estate attorney who said she might have a case if she could document harassment from the dealership. Her sister asked what harassment. The woman replied, "Nothing yet, but I need them to respond badly so I have something." 3 days later, she attended a dealership service appointment, her own vehicle on record, during which a verbal altercation with the service manager was captured on the facility's interior security cameras. Footage showed her raising her voice first. She had created the confrontation she needed. The judge did not need long. She ruled in favor of the dealership on all counts. The woman received nothing. The judge further found that the lawsuit had been filed in bad faith and ordered the plaintiff to cover the dealership's legal fees, a figure that came to $47,200. Outside the courthouse, the dealership's owner said only that he was grateful the truth had room to surface. The woman did not comment. Her attorney withdrew from any further representation within the week. The pale yellow house went on the market 4 months later. It sold below asking price, not because of noise, but because, in a neighborhood that talks, reputation travels faster than any PA system ever could. The acoustical engineer's report remained in the record. The sleep study was real. The exhaustion was probably real. But somewhere between a genuine grievance and a calculated lawsuit, the woman had made a choice that erased every legitimate complaint she may have ever had. Which raises the question the courtroom couldn't answer. If the noise had truly been keeping her awake at night, does manufacturing evidence make her story less true or just less provable?